2nd, 2025. This is What is HOA? What is HOA is a live stream podcast about HOA current events, various aspects going on in the country, USA, about HOAs. And this live stream is brought to you by Zayuk. Zayuk is a company that provides reserve studies inspections as well as an HOA platform for HOA management platform for your property or your property management company to intake the data coming from your reserves or work with them. Additionally, we provide many other HOA management features such as ticketing, workflows, reserves, not reserves, operating budgets, contracts, invoicing, vendor management, as well as voting. So we provide an entire suite of infrastructure for people to work with and manage property in a decentralized format. So we'll begin today. This is from KSL TV. Provo homeowners face big HOA fee increases over defective decks. And this is coming in the wake of Utah bringing in an HOA ombudsman office and a new group to manage various incidents between residents and HOAs as they pertain to Utah code. That's in accordance with what they say. People living in the Independence Avenue community are preparing for a big increase in their homeowners association's fee to fix a slew of defective decks. Every homeowner has to pay, even if their house isn't part of the problem. $2.8 million increase will be used to fix decks across the community, which is located near Independence Avenue and 820 North. According to the HOA, the problem lies with support beams which weren't built properly and let water inside, rotting the wood and putting the decks at risk of collapse. The cost per unit is $17,550, according to the HOA. Every homeowner is required to pay per the HOA rules and regulations. Huge amount of money to just conjure that out of nowhere. And they're showing an image and it looks cracked at the support beam, as they said. And it was due to support beams weren't built properly and let water inside. KSL requested an interview with Georgetown Development, but did not hear back. Homeowners face a choice: pay the entire cost up front over 15 years, but with interest. Homeowners have considered selling, but feel trapped. That's a very difficult situation. There are construction defect lawyers. I don't know about Utah. Here in California, I'm sure there are. Let's go. Construction defect lawyer, Utah. I found several in Salt Lake City, Sandy, Utah, St. George, Utah. I think I found some in Provo. I'm not going to name names, but construction defect lawyers handle these types of incidents. And if you reach out to one within your state, you can speak with them, see that, consult with the rest of your HOA, verify this is something possibly worth looking into. I think for that HOA on Independence Avenue and near, I think, 820 North, it's certainly worth them considering working with a construction defect lawyer if it looks like that and determining a route forward for seeing what's possible, seeing if there is certain liability held, then the lawyer, I'm not a lawyer, none of this is legal advice other than to say to go to the lawyer. And that's not legal advice either, but they will give you the proper analysis. They will be able to interpret your situation against the state code and against your own regulations and construction defect, possibly get an HOA lawyer in there as well. And then whatever that may be, I mean, when you're paying $2.8 million, the attorney fees will add up, but so will, there might be some justification, and it may be in the HOA's interest to do that. And they will determine that. That's a difficult situation for people, and something that you see here in Utah, you're seeing it everywhere in Florida. Florida is particularly susceptible to this due to multiple reasons, which we've discussed in depth throughout this live stream. Okay. Wow. This is quite a headline article, and I'm going to read it. The headline of this article by the Daily Beast: a strongly worded letter from Donald Trump's HOA. From one president to another, there's some property violations to address. That's their occupant. Oh, 1600 Pennsylvania. This seems like a troll. This seems like a troll. It is a troll. I'm not going to read this. Sorry, everybody, for getting into that. This is from San Diego Union Tribune. Amending HOA CC&Rs, the vote failed, so what now? So now what? Postponing opening of ballots to provide homeowners with further time to vote is common, but Civil Code Section 5120 prohibits opening ballots before the announced time for vote counting. Question: updating bylaws and CC&Rs. We needed 51% of the members to vote for the bylaw changes, but 66% to change the CC&Rs. Board refused to give us a red line document, instead just sent us the final version and went piece by piece through. Vote for bylaw changes needed more votes. A board member moved to postpone the vote to reach out to people who had not voted. And when the bylaw vote came up again, it passed by one vote. The CC&Rs needed way more votes to pass, so they didn't address that. And this person is asking, they believe they're only allowed to extend a vote if you could not get quorum, which in this case they did have. So can they reverse the vote, getting now more people to vote to reverse? And this is by JP, or this is by a fellow of the College of Community Association Lawyers and partner of Richardson Ober LLP, Kelly Richardson. Answer: board proposed a major governing document revision without sending a red line draft to the members, violated Civil Code Section 511G, 5515G, requires that the text of the proposed amendment be sent to members along with the ballot, unless the election is electronic, in which case the proposed amendment can be sent electronically. If the HOA sent a non-red line final version document, then the amendments were essentially hidden. Not only did this violate the statute, but it made it much harder for membership to approve the amendments. Postponing the opening of ballots to provide homeowners further time to vote is common, but Civil Code 5120 prohibits opening ballots before the announced time for the vote counting. Might be time for the HOA to start over, but this time pursuing the process correctly. Question 2. Builder put in CCRs. To amend it, there has to be an approval of the membership and mortgage lenders of 51%. Is there any way around this regulation? Fortunately, the appellate court ruled in 2008 that HOAs need not actually receive votes from each mortgage lender when lender consent is required by the governing document to approve certain amendments. In Fourth La Costa versus Scythe, the court held that because the HOA mailed notice to the lenders by certified mail, return receipt requested, and gave them a reasonable time, 30 days, to respond, the lender's failure to respond could be deemed consent to the amendment. Ascertaining the lenders takes some research, but recorded mortgages are public documents. Received 3 responses from lenders, and they were simply questions regarding whether the lender must do something with the notice. Assuming your HOA attorney is experienced, are familiar with Fourth La Costa, and should be able to help your HOA on this. Interesting. Okay. Missouri HOAs can ban chickens in their backyards. Missouri judge ruled that HOAs can once again ban people from raising chickens in their backyards. Struck down in 2020, Cole County Circuit Judge Brian Stump struck down a 2024 law that had prohibited HOAs from restricting backyard chickens, ruling the legislation violated the Missouri Constitution's clear title mandate and single subject legislation rules. Missouri lawmakers last year approved legislation that allowed residents to keep up to 6 chickens on lots at least 0.2 of an acre in size, even if HOA rules said otherwise. Also included are provisions to ban local moratoriums on evictions and regulate EV charging stations, sewer districts, and tax credits. The judge's ruling indicated the lawmakers had engaged in log rolling, a practice of combining unrelated issues into a single bill to secure broader support. Ruling stems from a lawsuit filed in August 2024 by Four Seasons Lakeside's Property Owners Association, which argued the chicken law was unconstitutional. The decision could still potentially be appealed by Missouri Attorney General Catherine Hanaway. Wow. That's a very common thing, I believe. And this is the roll-up log. We have that in California here. Yep. Okay, so Missouri backyards are now held obligated to the rules about chicken coops within their HOAs once again. This is from the Las Vegas Review-Journal. Originally submitted an application for a 12-foot by 24-foot pergola, but homeowners associations restricted me to a 12 by 12 foot. Attended a board meeting and requested a reduced size of 12 foot by 20 foot, but still denied due to aesthetics. Other homes in the community with larger structures such as pergolas, gazebos, and even a baseball cage, many of which have been in place for quite some time. I don't really know what a pergola is. Okay. And then a gazebo. It seems very similar. A pergola and this. Okay. I mean, seems very similar. Pergolas have an open roof of beams and rafters, while gazebos have a solid closed roof. Got it. Placed freestanding pergola to see the difference in aesthetics. A few days later, I saw a community ambassador driving around taking pictures, so I assume I'll be getting a violation. I've carefully reviewed the covenants, conditions, and restrictions and bylaws, and I found no language specifying dimensions or size limitations for such structures. Overall impact, aesthetics, and consistency appears subjunctive and inconsistent when other large structures remain in place. Concerning around Nevada Revised Statutes 116.31065, which requires associations to adopt and enforce rules in uniform and reasonable manner. Selective enforcement undermines fairness and may expose the board to claims of discrimination or arbitrary decision-making. Planning to file a complaint with the ombudsman and present my evidence. Before I proceed, I would greatly appreciate any advice you could share. NRS 116 does not address your architectural issue. As a homeowner, you do need to review your governing documents as to the authority of an architectural committee or the board of directors in approving or denying architectural requests. Authority is very broad and subjective. Limitations. Architectural guidelines cannot conflict with federal, state, or local laws. Decisions must be in good faith. Records to maintain why variance has been granted. Where the rules and regulations should be consistent, the physical differences for the properties within an association can justify decisions. Nevada Real Estate Division provides options from intervention to mediation to arbitration. Wow. This is also from the San Diego Union Tribune. Carlsbad's Planning Commission has approved 12 condominiums for Jefferson Street, single-family home. City's old water pipes made with asbestos, which is a carcinogen, widely used to reinforce concrete water and sewer pipes from the 30s through the 70s. Carlsbad's downtown water supply system are considered safe unless broken or damaged to release the asbestos. Quite a bit to phase out, and it's going to take time, said the assistant utilities director. New connections to the old system require precautions, must wear protective equipment to prevent them from inhaling asbestos fibers, workers. To prevent releasing any asbestos, whole sections of the old pipe are uncoupled from their connections without cutting. The old sections are replaced with new polyvinyl chloride PVC pipe. North of Laguna Drive, 0.34 acre lot, bordered on all sides by multifamily developments. House was built in 1947. One of the concessions allowed the project under California's density bonus law is that the developer is only required to replace sections of the water main where new connections are made. little more than 20 feet or 3 7-foot sections. Normally, the city would require the replacement of the water main across the property's entire frontage, or in this case, 100 feet. Developer said, Commissioner said the developer should be required to replace the entire 100 feet because it would be safer and relatively low expense compared to overall construction. Quote, I'm concerned that once you tamper with one of these particular pipes and don't complete the whole process, we're not going to ding a continuous benefit for the neighbors, unquote. Taxpayers eventually will pay to replace the pipes if the developer does not. The developer said his company will pay for the overall pipe replacement as part of the fees it pays for the city project. Pays the city for the project. Density bonus law. As much as people like it or hate it, it's a pretty strong law. Project includes one condominium that will be deed restricted for very low income tenants. Wow. Well, thank you, everyone. Hopefully, you're all taking care and having a great week.